Gentlemen, and good afternoon, Dr. Lowell Bautista in Australia. The Honorable Dr. Trilaksmi Indreswari S.A.M.Hum, as Vice Dean of Academic and Student Affairs, Faculty of Law, Universitas Diponegoro. The Honorable our visiting lecturer today, Dr. Lowell Bautista, LLB, LLM, as International Law Officer of School of Law, University of Wollongong, Australia, and Head of Postgraduate Studies at the School of Law. Ladies and gentlemen, I would like to express a gratitude for your presence and a very warm welcome for all the participants and students. It is a pleasure to have you all here today. We also thank God for His blessing that this morning together here for general lecture regarding of South China Sea dispute and maritime security in Southeast Asia. Before we begin, please allow me to read the agenda of the session. First, we will hear welcoming speech from our Vice Dean. Second, the lecture will welcome by the moderator, Mr. Pulung Widihananto, SH, MH, LLM. Third, the presentation will be delivered by our guest lecturer, Dr. Lowell Bautista, LLB, LLM. Fourth, there will be a question and answer session. And lastly, there will be a brief photo session. Ladies and gentlemen, without any further ado, we will hear welcoming speech from our Vice Dean, Dr. Trilaksmi Indreswari S.A.M.Hum. The time is yours.
The Honorable Professor Dr. Ratna Saraswati S.A.M.Hum, Dean Faculty of Law, Universitas Diponegoro. The Honorable Dr. Lowell Bautista, LLB, LLM, from Wollongong, Australia. The students and all participants, Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. Alhamdulillah, let's thank to Allah Subhanahu wa Ta'ala so that this morning we could join here in this visiting lecture virtually. On behalf of Faculty of Law, Universitas Diponegoro, I am privileged and deeply honored to welcome our special guest, Dr. Lowell Bautista, LLB, LLM, from University of Wollongong, Australia. We would like to express our heartfelt and highly appreciation for Dr. Lowell Bautista for accepting our visiting lectures invitation. We do hope you can visit us, Faculty of Law, Universitas Diponegoro, in the future, not only in virtual. In this grateful occasion, visiting lecture, Faculty of Law, Universitas Diponegoro intends to develop our students' quality and knowledge. I do hope the collaboration and networking between Wollongong University and Faculty of Law, Universitas Diponegoro will always continue. To all participants, thank you for joining this program and have an enjoyable and fruitful visiting lecture. Wassalamualaikum warahmatullahi wabarakatuh. Thank you.
Thank you very much, Dr. Trilaksmi Indreswari S.A.M.Hum, for this. Ladies and gentlemen, before we begin our discussion, I would like to introduce our moderator today. Our moderator today is Mr. Pulung Widihananto, SH, MH, LLM. He received his bachelor degree from Universitas Diponegoro and then received his master degree from University Kebangsaan Malaysia and National University of Singapore. He is also an advisor in FCA Chapter Semarang City, and now a lecturer in International Law Department Universitas. Mr. Pulung Widihananto, the platform is yours.
Okay, thank you, Bianda. Okay, am I audible? My voice? Okay, thank you very much. So before I give the floor and screens to Dr. Lowell Bautista, let me introduce myself actually in a brief line. My name is Pulung Widihananto, and I'm also international law lecturer in International Law Department in Faculty of Law, Universitas Diponegoro. So echoing what the statement delivered or speech delivered by the Dr. Laksmi, actually I think it is an honor and also the privilege, to get the notable speaker in here, very expertise in the law of the sea from Dr. Lowell Bautista. And we are thank you very much for accepting our visiting lecture. I think it will give some beneficial, very beneficial, mutual beneficial for our skills for our development of our students in the term of the knowledge, especially in the practical. And as we can see that the topic that we talked today is very, very, yes, polemic, because Indonesia is the member of the South China Sea, and we got a Natuna F there. So you know that. So it will be have delivered also with Dr. Lowell Bautista. So I think that from the all have the participant, please, you can learn carefully with the visiting lecture today. So with that, before I start the function, and I would like to begin to read this curriculum vitae from the Dr. Lowell Bautista. Dr. Lowell Bautista actually is a senior lecturer and head of the postgraduate studies at the School of Law and the Australian National Centre for Ocean Research and Security. And also, the current position is head of the postgraduate study, in University of Wollongong from the December 2020 to present. So besides of that, is also the member of the Faculty Research Committee, Faculty of Business and Law in UOW from the December 2020 to present. And regarding about have the qualification or background of the education, actually from the diploma, he got from the Rhodes Academy of Ocean Law and Policy in 2003, and also the Bachelor of Art in Political Science and cum laude in University of the Philippines in 1994, and also the Bachelor of Law, University of the Philippines in 1998, and pursue about the postgraduate in Master of Law in Delhi University in 2005, and also PhD or Doctor of Philosophy in University of Wollongong in 2010. Wow, it's very remarkable and outstanding curriculum vitae. So without any further ado, now I'm giving the screens to Dr. Lowell Bautista. The floor is yours.
Okay, give me a minute. I'm just setting up the share screen.
Yes, doctor. You still have got the time. No worries.
Okay, are you able to see my screen?
We can see that.
Okay.
Confirm, yeah.
Good morning. Salamat pagi. Terima kasih banyak. Before I begin, please allow me to express my gratitude to the Faculty of Law, Universitas Diponegoro, for the gracious invitation to speak with you today. In particular, I want to thank Professor Dr. Retno Saraswati, the Dean of the Faculty of Law, Universitas Diponegoro, and Dr. Tri Lakshmi Indraswari, the Vice Dean for Academic and Student Affairs. Thank you also to particularly to Pulong Widhi Hananto. I'm so sorry. Hopefully I'm not mispronouncing your names, and also to Rahandi Rizki for their excellent organization of this virtual lecture. And I'm also very honored, privileged, and I'm very particularly happy to speak with you today. And as Pulong Widhi Hananto mentioned, and also your Vice Dean, I look forward to visiting Semarang at some point in the future, and hopefully we'll have the opportunity to see each other in person. So as I was speaking earlier, I hope you're all in the best of health. I know it's not the most ideal of conditions, and we are in the middle of the pandemic. And I personally extend my my best of wishes to everyone, the students. Hopefully, this afternoon session will be beneficial for all of you. You will learn something, and I particularly welcome the opportunity to answer your questions toward the end. So I kept my presentation brief. It's particularly difficult to cover such a huge topic in 45 minutes, but hopefully I will give you enough material to ponder and think upon. And then at the end of the lecture, of course, I'll be more than happy for a robust discussion. So if you have questions, you can write them down, and I'm sure the host, Bianda, will also be happy to moderate later on. So the topic assigned to me today is South China Sea dispute and maritime security in Southeast Asia. And please allow me to preface my presentation with this quote from James Deacon. So if you can see from your screen, it says, what you see depends on not only on what you look at, but also on where you look from. So let me repeat that. So what you see depends not only on what you look at, but also on where you look from. And I think this is a very important and very thoughtful quote, which it's really very true. Life really is a matter of perspective, and I think it's also very sound advice. It's something which is full of wisdom, and personally and professionally, you know, it took me an entire lifetime to learn and apply this lesson. So today, as we look at the South China Sea disputes, I want you to frame your thoughts around this quote, because really, not just the South China Sea dispute, but all throughout life, your career, your studies, how you look at things is all a matter of perspective. It's all about framing. So if you look at the South China Sea disputes, it's very complex legally, historically, politically. There are multiple layers that you can use to analyze the South China Sea dispute. I am trained as a lawyer, and sometimes it becomes almost a liability. So that frames my analysis. But of course, there are other ways of analyzing the dispute. So when you do that, I invite you to keep an open mind, and also to be aware of the multiple levels and frames of analysis. So yeah, what you see depends on not only on what you look at, but also where you look from. So when you think of the South China Sea, I'm sure you must have heard of the South China Sea previously, and probably you have very negative ideas of the matter. So if you think of the South China Sea, I just quickly made a Google search before the presentation. A lot of negative news about the South China Sea. Some people say that the South China Sea plays a destabilizing role in Southeast Asia. It is seen as a major irritant in the bilateral and multilateral relations. When we think of the debate in the South China Sea, you can imagine people think it's very complicated, not just because there's very complex legal issues involved, but there are also a lot of countries involved. So you have the 6 claimant states. Some scholars and commentators include Indonesia as well because of the Natuna, as Pulong already hinted at. If you look at the features in the South China Sea themselves, some of them are very tiny. Some of them are tinier than the table in front of me. Some of these features are really worthless in themselves, but they take on a very symbolic value because because of the context. They can serve as legal points for jurisdictional rights. There are also some discussion and thought about the resources in the area. We'll go to this in a while. And of course, there's also the strategic layer happening. So we're all aware that there seems to be a proxy war between the superpowers going on in the backyard. So you have the United States of America, a global superpower, on its way down or decline, and then a new global superpower on the cusp of rising, and that is China, economically, militarily. There are also a lot of issues involved. So you have freedom of navigation, you have trade, there's also resource questions, fisheries, among others. 10% of the world's fisheries resources come from this region. When you talk about the protein sources of the littoral states, most of them come from fish, and this fish is, of course, sourced from the South China Sea. So all of these multiple layers of looking at the issue, the legal, the jurisdictional, the political, the strategic, the economic, trade, navigation. So it's really very, very complex. And I wouldn't be surprised if you get overwhelmed when you analyze these things. So hopefully, as I said, I invite you today, keep an open mind and be aware of these multiple layers of complexities. So if you ask me what is the current situation in the South China Sea, in my personal analysis, I think the situation in the South China Sea could be marked by the 5 realities that you see on your screen. So the first one I flagged there is an escalation of maritime confrontation and resource conflict. So if you look at the region, there's really a worrying kind of escalation of maritime confrontation and resource conflict. So we see this almost on a daily basis, sporadically and continuously over the years. So in 2012, as you would probably be aware, because of the Scarborough standoff that happened in the Philippines was forced to file a arbitration. We've seen this in 2013 when Taiwanese fishermen were forbidden to fish in waters. We see this between Vietnam and China in 2012. I was looking at the news just a couple of days ago. The Indonesian Navy actually deployed 5 naval vessels in Natuna Islands because there seems to be some Chinese vessels in the area. So, and then you just recently China passed a new Coast Guard law. So the South China Sea is always in the news. There's always something happening there. There's always seems to be a threat of open confrontation, and definitely the risk of maritime confrontation. So all the countries seem to be very invested in furthering their claims, making sure that the asserted claims of China are curbed. And of course, that brings us to the second point. There's increased tension and the risk of potential conflict. If you look at the geography of the South China Sea, it's not a very big body of water, and the islands and features and rocks and cays there make it even smaller. And some of these are deep. Some of them are, of course, shallow. And imagine if you put all of the maritime assets there, there's always a risk of a miscalculation. So if you have the freedom of navigation operations from the US, you have Chinese vessels operating, you have you'll soon see the artificial islands and so on. So there's really an increased risk of possible miscalculation. And then you have increased assertiveness over the territorial claims. We've seen this in various acts of the countries. For example, in the part of the Philippines declared the South China Sea the West Philippine Sea. I think Indonesia also declared the EEZ over the South China Sea as West Natuna in 2017. You have a flurry of other domestic legislation within the claimant states passed in order to assert their claims. And of course, this all solidifies their claims as well as makes their position very intractable. Because when you legislate, it actually becomes harder to pull out. And if you speak to a domestic audience, that heightens their sense of nationalism. It makes it even more difficult for the policymakers to have an accommodating position. And as I said, the South China Sea is a stage for a power struggle between China and the United States. There seems to be a proxy war happening in the background, in our own backyard. And you see these two global superpowers, vying for the topmost position. And all of these things challenge ASEAN unity. The centrality of ASEAN is challenged because the Chinese, they use checkbook diplomacy. They use their economic clout and influence and relations with the countries. We've seen this very, very strongly in 2012, I believe, in July 2012, when the ASEAN was not able to issue a joint communique because the South China Sea dispute is something that really divides the ASEAN and their loyalties. And even in the negotiating table, when they formulate ASEAN position papers and documents, it's always difficult to even mention in the text South China Sea. So it really divides and challenges ASEAN centrality and unity. So if you ask me, all of that happening in the background, the rivalry, the intense assertiveness, the naval forces from all countries, the domestic legislation, do you think that the Southeast Asian region is stable? You might be surprised to find out that I actually think that it is still, with all of that. I strongly believe that the Southeast Asian region is still relatively stable. So it's a stable maritime region. And if you look at the analysis, the sources of stability actually are subject to a theoretical orientation. What do I mean by that? So if you look at the scholarship, if you look at the academic commentaries, they would argue that the region is stable, but the way that they premise that will be depending on where they're coming from, their theoretical perspective. So for liberals, for example, such as Akinberry and Chukuyama, they would say the region is stable because of economic interdependence. There's multilateralism, there's a spread of democracy. So for example, in ASEAN, you can see that the countries are very economically interdependent. ASEAN is actually the largest trading partner of China. And in 2020, the trade between ASEAN and China reached 73.9 billion. And it represented a 7% growth year on year. So you can see that because of this, economic interdependence, you can already assume it would be very difficult, because some analysts would tell you that it's unstable and therefore war will eventuate out of the conflict. I would hazard that it's really very far-fetched, because if you see, it's war or conflict is really not to anyone's interest, and you can already look at that from an economic perspective. It's not economically viable for these countries who trade with each other and so interdependent with each other to actually go to war, which is a very costly endeavor. You can also say that it's stable because of multilateral institutionalism and the spread of democracy. So you have a very strong, very robust regional architecture. I don't have a slide, but if you can imagine within the region, there are multiple architecture that governs the relationship. ASEAN is one, the ARF. You can also, you should be aware that they're all signatories to the UN Charter, for example. They're all parties to the UN Convention on the Law of the Sea, except for Taiwan. So there's really, very robust, strong, time and tested institutions that ensure the stability. There's also a balance of power persuasion. So you can see that the United States, because of its primacy as an important military power, really underwrites the security of the region. And you can also argue it's stable because of a Pan-Asian identity based on shared values and norms. And along these lines, you can find scholars such as Acharya. So all of these arguments or theories or perspective will, support the proposition that despite the challenges in the South China Sea, it's really a very stable maritime region. So I'm saying South China Sea region here, but now some scholars would say, if you move further afield, you can think of it as the Asia-Pacific region or the Indo-Pacific region. So it's all the same. It's just a loose terminology referring to the maritime area, and that's where you situate the South China Sea in a broad context. So this is really a preliminary discussion. So with all of these points, this is just a brief outline of my presentation. And as I said, it's difficult to cover this in 45 minutes, but this is where how we will proceed. So the first part, we will look at an overview of the South China Sea disputes. In the second part, where are we now? We look at the arbitration case filed by the Philippines versus China in was decided in 2016. We will look at the awards, some of the claims that the Philippines has asked the tribunal to rule upon. There's a flurry of pictures just to flag the reclamation activities undertaken by China. And finally, in the last part, we will look at the relevance of international law, some implications, options, and some brief recommendations and final thoughts. So before I became a full-time academic, believe it or not, I was a practicing lawyer. So as Pulong and Handy mentioned, I am originally from the Philippines. I came to Australia in 2005 to do my PhD and have been here. But before, in a previous lifetime, I'm actually a practicing lawyer. So one of the things that I recall I have learned as a lawyer is that clients come to you for advice, for legal advice, and I believe you're all law students. So you will be in this position very soon when you finish your law degree in Indonesia. So they come for you for advice, and of course they normally ask you what are the chances of a case succeeding. And in my years of law practice, one thing I've learned is that you have to always be honest. It's always best to be honest. So please allow me to start with the bad news. So I'll start with the bad news, and then we'll of course go on to the good news. So the first bad news I want to flag there is that the Philippine arbitration case, which is the case filed by the Philippines against China, does not resolve the dispute over the South China Sea. And the Law of the Sea Convention does not contain rules which will resolve the dispute over the South China Sea. So the Philippines filed a case against China at huge economic cost and political cost. Fortunately, the Philippines won that case, but unfortunately, if you look at the dispositive and how the case is structured and the international is structured, it does not resolve the dispute in terms of who owns the islands or the territorial issue of the South China Sea dispute. If you look at the Law of the Sea Convention, although all the parties except for China, except for Taiwan, are parties to the Law of the Sea Convention, unfortunately, the Law of the Sea Convention proceeds from a premise that land territory is recognized, and it also does not contain any rules which will tell you who owns the islands. Okay, so, and sadly, the reclamation activities that the Chinese have conducted in the features that they have built artificial islands upon have caused irreparable damage to the marine environment. I have a few photos later on just to illustrate this. So of course we have a legal victory by the Philippines, but the reality on the ground is really very dire because you have the Philippines sadly losing physical occupation of Scarborough Shoal, and then all of this damage to the marine environment. So you'll soon see, you can just do a quick Google search. You'll find out that really these structures are quite massive, over 3,200 acres of reclaimed land. And in doing so, they had to dredge the islands. They have to, they say they even have to, bring sand from the Philippines to the South China Sea. And doing that, has really caused massive irreparable damage to the marine environment. And if you find a copy of the arbitral award, you can read there. There are independent reports which tell you that millions of years that nature took to build the reefs and the corals and all of this delicate environment, have been damaged, and they're irreparable. That you cannot turn them back, and that's of course the sad part. And finally, from a legal perspective, nothing could be worse than your other party not honoring, assailing the validity, the legitimacy of the award. So China has made it clear from the get-go, consistently throughout and afterwards, that it will not honor the award. It will not implement the award. Okay, I think I need to hurry. Time flies. Okay, so looking at some of the good news, of course, the award is an overwhelming legal and moral victory for the Philippines. If you look at how the case was formulated and won, the Philippines really assembled a strong legal team, Paul Reichler et al., and they're really the most experienced legal team that you can find in terms of sovereign disputes governing territories. So it's an overwhelming legal and moral victory. If you look at the award, the final award, it's 500 pages. You can see almost every point that the Philippines raised, the tribunal agreed with the Philippines. Before the South China Sea arbitration, the Chinese always tell you, and have been into many conferences and I've written papers about this, they normally say that China has indisputable sovereignty over the South China Sea because of the 9-dash line. Fortunately, after the 2016 award, you should not entertain that anymore, because it was categorically declared by the South China Sea Arbitral Award that the Chinese 9-dash line has no basis in international law. It's incompatible with the United Nations Convention on the Law of the Sea as well. From a legal standpoint, again, it's final, it's binding, it's enforceable, it carries huge presidential weight. So there's no provision for appeal. And regardless of China's participation, China has to honor, and it's bound by the award. Okay, just a brief background. As I said, many of us will be aware of the South China Sea. We're very familiar with the literature. Geographically, the South China Sea is very important in terms of geopolitics in the Indo-Pacific region. It's important and contentious for two reasons. Because of its geostrategic significance. The South China Sea is a major sea lane of communication. Over half of the world's annual merchant fleet tonnage passes through the Straits of Malacca, Sunda, Lombok, and they continue onto the South China Sea. A third of global crude oil and over half of the world's LNG trade passed through the South China Sea. How much is it worth in terms of trade? $3.37 trillion passed through the South China Sea in 2016. It's very important. 40% of liquefied LNG also passed through the South China Sea. So the powerhouses of Japan, Korea, and so on, they have to go through the South China Sea. So it's a very important, maritime choke point as well. There are also estimates of huge hydrocarbon deposits, 11 billion barrels of oil, 190 trillion cubic feet of natural gas. Of course, the Chinese estimates are even higher. We can also speak of the fisheries, which is also a very important, valuable resource, not just economically, but also, as I said, a source of protein for the littoral states. And also, the geostrategic significance. It consists of 4 groups of islands or archipelagos, as you can see on the screen. If you look at the claimant states, they have there are over 200 insular features in the South China Sea. About 60 of these are occupied. So China occupies 7, Taiwan occupies 1, which is the largest feature, Itoaba, about 1.4 kilometers in length. The Philippines occupies 9 features. Vietnam occupies the most with 21 features. And Malaysia occupies 5 features. Why is the dispute complex? Because it really involves, as I said, the layers of complexity involving international law, geopolitics, economics, international relations. Over the course of the years, many of the claims have actually now aligned with international law. So you see rhetoric really mimicking, words and concepts of international law. So they now have some sort or semblance of terminology that are almost international law or law of the sea in form. And you can see this even in the articulation of Chinese claims. But however, as I said, the UNCLOS or the Law of the Sea Convention, unfortunately, has no provision for determining sovereignty. So if you want to, so there are 2 types of dispute in the South China Sea: the territorial dispute and the maritime jurisdictional dispute. The territorial dispute refers to the ownership or sovereignty over the islands. If you want to settle this dispute or issue, unfortunately, the Law of the Sea Convention is not where you look for the answer. You have to find them in the corpus of cases where title to territory is decided. So not the Law of the Sea Convention. Again, just a depiction of the South China Sea being a tale of complexity. So this map, if you look at the screen, you have all of the overlaying baselines and base points, the claims from the maritime or littoral states. It even has the joint maritime seismic undertaking zone, all the zones from the occupied island. So all of this gridlock of lines really illustrate how complex it is. And it's just for emphasizing that point as well. So where are we now? So with all of that in the background, so just to move us along, so the reality we have to contend with is the arbitral award of July 12, 2016. And I think the reclamation activities of undertaken by China. So if you look at the screen, you'll find some pictures, and I have a couple more, which I will flash very, very shortly and very quickly after this. So within a very short span of time, we saw very rapid construction from China of artificial islands in the Spratlys, which, as I said, they radically changed the geography and the security landscape of the South China Sea. So there were really massive island construction, over 8 million square meters of real estate in the open sea, about 3,200 acres of reclaimed land. So you can see that all of these features are subject to sovereignty disputes, and they're built over these features. If you look at the award, as I said, the arbitral tribunal award made it clear that these features, they're artificial in nature. They constituted a violation of the obligations of China under the United Nations Convention on the Law of the Sea. And they also highlighted the fact, as I said, they cause irreparable damage to the marine environment of the South China Sea. So how does it figure or compare to the other reclamation activities of the other claimant states? The other claimant states reclamation activities in total, the yellow part on the screen actually is dwarfed by the land reclamation done by China from 1970 to 2015. So you can see the massive and the extent of the reclamation undertaken by Beijing. So it's really not really catching up, but it's a whole new game and level unto itself. So just to illustrate and highlight that point that I mentioned. So the next couple of slides I will just flash through. It's just to drive home the point that the massive reclamation caused irreparable damage, and you can compare. So I invite you to do a quick Google search. There are a lot of free images and websites which illustrate this. Some of these images actually that you will see are a bit dated, but it's just to illustrate, as I said. So Fiery Cross Reef or Kagitingan Reef in 2012 and in 2015. So you can see as a point of comparison or scale, the ships or the dredgers there. These are massive structures. So the reclamation undertaken by China. This was supposed to be the proposed air base and strip, and in 2015, I think this is already operational by now. So it has a 3,000 meter or 9,800 feet runway, and really you can imagine how China will be using this as a for military purposes. The Chinese air naval base on Kagitingan or Fiery Reef. You have a picture of the Johnson South or Mabini Reef pre-proclamation, and a picture in 2015. So you can imagine all of those small features. I hope you can see in your screen. They're actually buildings. So the reclamation work expanded the surface to 10.9 hectares or 27 acres. There's a military and radar base. There's even a small harbor. There are photographs in 2016 which suggest that there are close-in weapon systems or missile defense systems in place. These are all in the Philippine EEZ, by the way. Before, they used to be classified pictures, but now you can just Google them. They're all declassified and I think freely available. There are even more recent ones available. McKinnon Reef or Chigua Reef pre-reclamation, again, within the Philippine EEZ. And then a picture of McKinnon Reef or Chigua Reef in 2015. So you can see the difference in scale and size and all the features. There's a facility there which is insetted. It's a multi-story building. Gavin Reef in 2014. That very tiny original structure existed then. And then Gavin Reef in 2015. You can see there's all of these naval platforms. There are radio communication equipments there. There's anti-aircraft guns and so on. So it's really been massively reclaimed. Calderon Reef pre-reclamation and then in post-reclamation in 2015. Again, you can compare and appreciate the difference in the original state and the 2015 state. Subi Reef pre-reclamation and Subi Reef in 2015, the 3,000 meter runway structure there, and Woody Island. Mischief Reef, as I said, it took nature 30 million years to work on this work of wonder, and it only took China 1 or 2 years to, so to speak, damage it irreparably. So you have all of these developments undertaken by China. So now we'll look at the arbitration case filed by the Philippines, and I won't spend too much detail in dissecting it, but all of these things, all of the public records are available for you to read. You can go to the Permanent Court of Arbitration website. You'll find there the pleadings. If you have the time, the inclination, and the interest or the curiosity, you can find the pleadings. You can find the the annexes. You can even find a transcript of the oral hearings and so on. So it's very, very, very useful. Thankfully, it's all publicly available. So it all started in 2013. The Philippines submitted a notification which is allowed under the UN Convention on the Law of the Sea, which started the arbitral proceedings. Of course, the Chinese returned that and rejected the notification. Even from the get-go, it said it wouldn't participate, it wouldn't honor, it wouldn't recognize the tribunal as well as the award. Outside of the arbitration, China submitted a position paper without admitting jurisdiction on the 7th of December 2014. The tribunal requested additional information in 2014. The Philippines submitted supplemental written submission in 2015, and hearing commenced in July of 2015. So these are just very procedural points. As is usual in interstate disputes, the proceedings were bifurcated. So there was a hearing or trial based on the jurisdiction, and then there was a trial on the merits. So the jurisdiction and admissibility was finished in 2015, and of course, the tribunal ruled that it has jurisdiction to proceed with the merits phase. And then there were hearings on the merits in 2015. And finally, in July 12, 2016, the tribunal released its final award on the merits. So what did the Philippines seek in that case? The Philippines wanted the tribunal to declare that between the Philippines and China, what should be the international law governing the relationship with the UN Convention on the Law of the Sea. It also wanted the tribunal to determine applying rules of in the convention, particularly Article 121, which of the features are islands, which are low tide elevations, which are submerged banks, and what maritime entitlements that the Philippines has over those features. So if I invite you to look at Article 121, which defines the legal definition of what is an island, which is above water, natural feature at high tide, capable of sustaining human habitation and economic life of its own. And the tribunal, spoiler alert, declared that none of the features are actually islands. And because they're not islands, they're not entitled to an EEZ or continental shelf, but only a territorial sea. So in effect, it limited the scope of the dispute. What else did the Philippines ask for? The Philippines asked the tribunal to declare that the exercise and enjoyment of the rights of the Philippines in its EEZ should be respected by China. The Philippines, of course, was aware of the limitations of UNCLOS, as I said, because sometimes you look at the commentary, you look at the Chinese rhetoric, they were saying it's all about the issue of sovereignty, and this is not the proper forum. It's something that should have been filed elsewhere. Of course, the Philippines was aware of that. And of course, the legal team was also aware of that. So from the very beginning and all throughout, the Philippines does not seek a determination of who owns the islands or a delimitation. It's not part of the case filed by the Philippines. It's conscious of China's declaration of 2006. So if you look at part 15 of the convention, there's an Article 298 and so on. There are articles which tell you types of disputes which are excluded. And these are also mentioned in China's declaration. They were not included by the Philippines. They're mindful of that. A list of the relief sought by the Philippines, 13 altogether. So essentially that UNCLOS should be the international that governs the dispute, that the Philippines also wanted a declaration that the 9-dash line is not valid and contrary to the UN Convention of the Law of the Sea. They wanted a declaration that the occupation of China with respect to the artificial features are illegal. They also wanted a declaration that the China should terminate its occupation and other activities in the features that it occupies. It also wanted a declaration that the submerged features that are below sea level are rocks under Article 121, paragraph 3 of the convention. And because of that, they're only entitled to 12 nautical miles. They wanted the Philippines wanted the tribunal to require China to refrain from preventing Philippine vessels from exploiting its resources in its EEZ, which are rightfully guaranteed under the convention. It also wanted the declaration that China has unlawfully claimed and unlawfully exploited the living and non-living resources in the Philippine EEZ and continental shelf. So essentially what the Philippines is saying is that between the Philippines and China, we have the UN Convention on the Law of the Sea. The UN Convention on the Law of the Sea has rules which tells you which are within the Philippine sovereign rights to explore, exploit, and so on. And that should be respected by China. Okay? And that China should not interfere unlawfully with the exercise of its rights of navigation. So all of this add up to 13 reliefs. And thankfully, almost all of them, the tribunal agreed with the Philippines. So just, of course, as I said, it's a 500-page final award. There's so many aspects of it that you can focus on. If you ask me what are the 3 most important victories in the award, I've put them on your screen. Of course, number 1, the assertion of China that the claim is undisputable based on the 9-9 should not be respected anymore, because it's quite clear from the wording and pronouncement of the arbitral tribunal, China's 9-9 claim, as well as China's historic rights over the living and non-living resources in the South China Sea, find no basis in international law and incompatible with the UN Convention on the Law of the Sea. So remember that. Secondly, China's reclamation activities have interfered with the rights of the Philippines under the convention, and it's caused irreparable damage to the fragile marine environment of the South China Sea, and they clearly violate the obligation of UNCLOS under China's obligations under UNCLOS. Number 3, very important for defining the extent of the disputes and what to do after the award. None of the features are islands. As I explained, the island has a technical definition under the UN Convention on the Law of the Sea. Look at Article 121. And as such, they're not capable of sustaining human habitation or economic life of their own. And because of that, they are merely rocks. So Article 121, paragraph 3, which means they do not generate EEZ or continental shelf. So effectively, the court is saying, from here on forward, the disputes are limited, and it makes it simpler for the claimant states. Of course, there are still questions that remain, a lot of questions actually. The most important, and in fact, the critical question that remains is the territorial question. So who owns the features? We haven't settled that. So we don't know whether the features occupied by the Philippines, Malaysia, Vietnam, and so on, Brunei, over Louis, who owns those features? They haven't been settled because it's still subject of competing claims. What happens to the artificial islands? Are they illegal structures? Could you dismantle them? Is there a possibility of seeking reparation from China? These are navigational hazards in themselves. What do you do with this reclamation artificial islands? Moving on forward, what is the negotiating strategy of the claimant state? So some commentators and even diplomats think of the South China Sea Arbitral Award as a starting point, the bright red line, which should not be crossed when they sit in negotiations. It's technically only binding between the Philippines and China, but how does that affect the negotiations? Bilaterally or multilaterally? How is that a factor in the negotiating strategy of the claimant states? So I'm very close to finishing. I only have 2 more slides. So it's good that, if you look at the arbitral award, it's actually very positive because they made the rules clear. And because of that, there is really, a basis for better negotiations. The arbitral award and the tribunal and also the litigation exposed the illegal activities of China, which are inconsistent with the legal order, and it drew global attention to China's behavior. The agreement an agreement can be effectively negotiated if there are smaller numbers of actors involved, but of course it will always be a question of implementation, because if you look at the South China Sea dispute, it's complicated because it's a multi-party dispute. It's not just between China and the Philippines, because it also involves other countries, and that aspect hasn't been resolved. So across the negotiating table and how you behave as a country, you have to have this cost-benefit ratio. What benefit would it do to file a case? So it's not just the legal cost, because the legal costs could be exorbitant in themselves, but something compared to something, you know, which is incalculable in value. I recall, I think President Widodo mentioned at some point that when it comes to Indonesia's claim and sovereignty over Natuna Islands, it's not open for negotiation. So that's why I don't know if you're aware, but even in Philippine media and Philippine domestic commentary, the domestic politics and policies of Indonesia and the Philippines are always contrasted, and of course they always fall short because we have very serious domestic leadership issues in the Philippines when it comes to the South China Sea. And again, it also, as a final point, it draws attention to this regional hegemony. As I said, the proxy war happening. You have a global superpower on the cusp of rising, and then look at how it's behaving. So is that something that should be a cause for alarm or concern? And how is that shaping? How is global opinion shaping China's behavior? This is my final slide. So just a few thoughtful points that I leave with you. So I think the award, the South China Sea Arbitral Award of 2016, holds great presidential weight. It's very hard to ignore. It should be the starting point of any negotiations. The multi-layer analysis that I hinted at the beginning also applies to the post-arbitration scenario. So in so many ways, the job of the lawyers have almost been relegated in the backseat, because now it's the job of the diplomats to take charge. So it's always in the spirit of resolving disputes peacefully without threat to violence or the territorial integrity and sovereignty of the states. The state party should also exercise self-restraint. Of course, non-use of forces are all perentorial norms in the UN Charter. Very important, claimant state should pursue a rules-based approach based on international law, especially based on the UN Convention on the Law of the Sea, in resolving the disputes in the South China Sea. So many times I'm always part of many forums. I always think of throwing this question or this idea to the participants. So what is your preferred future? So your preferred future is something which is peaceful, where players follow the rules. That's why it's very important for us to honor, respect, and pursue a rules-based order, because without a rules-based order, it will be chaotic. So that's why the claim should follow the spirit and the letter of international law, and that secures all of us. Otherwise, it will be detrimental. There will be bloodshed. There will be conflict. So a rules-based approach is always the better approach, if not the best approach. So thank you for your time. I'll end my screen sharing, and I'll give the floor back to Bianca for moderation. I'll be happy to answer questions, and in fact, I'm excited to answer questions from your students, Pulong Widihananto.
Okay, thank you, Dr. Bautista.
Thank you so much, Makasi.
Yeah. Yeah, you're welcome. Actually, thank you very much for such very enlightened presentation. I think that as we can hear in here, I mean, like even in virtual, we can give some like many some information in regarding about have the certain conflict in the south of the China Sea, which is that in the presentation, Dr. Bautista was present in so many have very systematic term from he's just like mentioned from the historical first, and then the core of the problem, and until about the tribunal award, and until about the scenario itself. So until the conclusion, I think it's very, very perfect and also very informative, informative for our knowledge in terms of the case of the south of the China Sea. So thank you, Doctor. Now we're moving from the question and answer sessions. So I saw that in question and answer session, do that. Maybe they have also question maybe in the box on the chat. But before that, maybe I will offer from the student that maybe would like to asking directly to Dr. Bautista. Please raise your hand and turn on your microphone and direct your question or concerns. Is there any question rising on the floor? Please raise your hand. Hello? Is there any? Okay. Do that we waiting, doctor. Maybe you can also pay attention on the box on the chat. They also like the question for you, Dr. Bautista. Actually,
so I think there's a question here, Pulong, if I may read. So it says, thank you for the lecture, terima kasih for your kind words.
Yes.
Hafid Nugraha.
Yes.
I'm not a law student. That's good. I'm a geopolitics enthusiast. Excellent. What do you think about Indonesia's tendency to passive action to see potentially war in front of them? You know that even French, German, and UK carrier had already in SES. Thank you. So I don't know if I understand the question correctly, but as I said in the start of my lecture, I don't think, so if the question is, do you think like war is possible or open conflict or military confrontation? I think in my analysis, it's really very remote, because if you look at, as I said, the economic interdependence, it's really not an option, because war is very costly. It's not an instrument of national policy. It's also illegal and forbidden under international law. So I see this argument very, very strongly in the Philippines, because they always have this false dichotomy. Why should we be assertive against China? We cannot go to war to China. Let me tell you, I think China doesn't want to go to war as well, because in the first place, it's not assured of victory. So only states and people or countries who are assured of victory go to war. Plus, it's not in their interest. It will be economically damaging to their country, the lives lost. So I don't think I think a lot of it is it's about posturing, power projection, hedging, as I said, balance of power, politics, but not really. I don't think war will ever erupt. At least in my analysis, I don't think it will lead to that. So, and you don't have to apologize that you're not a law student. As I said, sometimes we're also preoccupied with the legal analysis. In my experience, sometimes it's the most basic and the most simple, and sometimes very, very deficient, because if you look at the law, it's very simplistic, but in the ground, it's more complex than that. It's actually very, very complex, more than the legal element. Hello, Dr. Bautista. The South China Sea dispute involves several countries in Southeast Asia. Is it possible for ASEAN, a regional organization, to challenge the claim coming from China regarding the South China Sea itself? Oh goodness. To be honest, I don't think so, because as I said, the inter-ASEAN trade between China is huge. The ASEAN is actually the largest trading partner of China. If you look at the individual countries, the Philippines, for one, I'll give you an example. China is its biggest trading partner. I'm not sure for Indonesia, but across the countries in ASEAN, they trade very heavily with China. So how do you challenge? Some scholars say this as checkbook diplomacy. So you see countries like Myanmar, Cambodia, to a lesser extent, I wouldn't say, maybe Singapore, not really actually, but more the Philippines. So it's the you can see foreign relations being very heavily influenced by its economic and trade relations with China. So they come to the negotiating table quite imbalanced, because you can already you can already anticipate if they go against China, then there will be serious repercussions. You'd be surprised, even for a country such as Australia. I don't know if you've been following the news. They've had every time Australia does something inimical to China's interests, or I think at least they think it's not good for them, they hurt Australia in terms of trade. So if you recall, in 2012, before the arbitration was filed, what did China do to the Philippines? They restricted banana trade. They would hurt you economically. So there will be heavy pressure from the countries to give in to China because they will be hurting the economy and people will be losing their jobs. The same for Australia. At some point, they were restricting trade in beef. They were restricting the trade in wine, and then now they're also restricting the movement of foreign students from China to Australia. So that's how they hurt you. It's really economic diplomacy. So it would be very difficult to have an independent foreign policy vis-a-vis China because of this, because of the economic entanglement. I think among the more vocal voices is Indonesia because you have a very strong president. But the other countries, it's very difficult. And it's not just within ASEAN because it's also further afield. Like Africa is the same, the Pacific Islands is the same, because you cannot deny, I mean, China is very powerful economically. It has, very deep pockets. So that, adds a further layer of complexity as well.
I think that's all, Doctor. But I have some question maybe to
yes, please.
Yes, maybe we can broadly open the discussion. Well, actually, I have 2 points, and my first point I remember when my professor in National of University of Singapore said that actually the one of the core of the problem, the conflict raised in Southeast China Sea, I think it's like the traditional water, which is that it's like occupied by 9 dash lines. So that's where the 9 dash line is always to be have the problematic, and China is always like strongly believe actually that they have fight against about their territory to just like develop or maybe make some like their water territory is maybe wide than like in UNCLOS. Meanwhile, in another side, that the UNCLOS say that this is contrary and not accommodating in one of the article or the clause instead, as well as the principle of international law. So actually in this context, so would you want to elaborate more in terms of the 9 dash line itself? Because I think that I'm very allergic if I heard about 9 dash line itself. That's my first point, Doctor. So maybe you can respond first, and then we continue with the second point. Thank you very much.
So, Pulo, are you asking about traditional fishing rights or about the
9 dash line and traditional fishing, actually?
Oh, okay. So if you look, that's a very good question because if you look at let's talk about first the 9 dash line, because the 9 dash line, it's the first time that China actually put the 9 dash line in a legal document was in 2009 through a submission to the UN Convention on the Limits of the Continental Shelves, UNCLCS. And then after that, Malaysia and the Philippines filed a diplomatic protest. But if you look at the line, it's like 9 in number, and before it was actually 10 or 11, and it disappeared in the Gulf of Tonkin. They never really took the time to explain to us what the 9 dash line means. But as I told you, sometimes they would say, or not sometimes, all the time they would say they have indisputable sovereignty based on the 9 dash line. The 9 dash line is a series of 9 dashes, which covers the South China Sea. So what do they say these lines are for? They covered either the waters or the islands. But if you look at international law, that's not how you claim territory. You cannot just claim a territory by drawing lines, because the international law on title to territory has a very defined sources of owning territory. So you have discovery, occupation. In the old days, you can use it through war and so on. So you have to have, and now if you look at the recent cases, it's all about effective occupation. So you cannot just say that you own islands. You have to prove that you have occupied the islands. You have sufficient legal basis to own them. You have exercised sovereign acts as a sovereign to prove your title to territory. So now after 2016, as I said, the principal victory is that China should not be allowed to say that there's a 9 dash line anymore, because it's not. It has no basis under international law. It's incompatible with the Law of the Sea Convention, because under the Law of the Sea Convention, all maritime entitlements proceed from the land. So the land is where you measure your maritime zones, your territorial sea, your contiguous zone, your EEZ, and so on. So without title to the land, you cannot have the maritime zones, simply speaking. So going back to the question of Pulong, so traditional fishing rights, it's very good because this question is very good because it's actually been raised in the arbitration. So the court said that there are traditional fishing rights in Scarborough Shoal, which applies to Indonesia, the Philippines, Vietnam, even Taiwan and China. But if you look at the concept of traditional fishing rights, it's supposed to be exercised over a long period of time. And in my opinion, they have to be, subsistence or artisanal fishers, because I don't know if you've been following the news. Very recently, China has been physically occupying large expanses of water in the South China. They are sending huge, fishing vessels. These are not the traditional fishers that the Law of the Sea Convention envisioned. Traditional fishing operations are artisanal in nature, subsistence. These are your small community fishermen who have been fishing in areas offshore for a long time. So I think Indonesia and Indonesia and Malaysia has this, the same with Singapore, because the seas used to be there used to be free movement among the you can see this in the Sulawesi Sea, even in the southern part of the Philippines. But these are not for huge fishing vessels that China operates. So traditional fishing rights only for subsistence fishermen, which are doing that for artisanal purposes, not for commercial purposes.
Yes.
I don't know if I answered your question, Pulong.
Yes, correct. Perfectly. You perfectly answered my question, actually. Because if I can add some information, Doctor. So we have a Natuna Island, which is that we claim economic zone also toward in also the south of the China Sea itself. But sometimes we also facing up about some cases that maybe in the traditional vessel of the China is also entered in our as easy. When we try to catch up with a Coast Guard, they always mention and always make pleading with very strongly that this is our traditional fishing area. That's why that we have claimed it. For a good second, that's why that for a good second, actually, that this is not correct at all with international law.
So that's yeah, sorry. Sorry.
Yes, please. Yeah, so that's why that we sometimes that, wow, how to do that China can be claimed in our EEZ, even though that we try to have like execute or practice the UNCLOS toward our international law, and we also try to also guardian with our Coast Guard, but sometimes they always like didn't hear our notification. Sometimes they always try to over and on over and over without any just like what our government said. Even that we try to be like diplomatic approach in also the governmental itself, like G2G between about half the Jakarta in Beijing. Sometimes that didn't hear it. So I think that is same. I think that I have a feeling also with our lovely neighbor Philippines. This is same actually.
Exactly.
Like, yes, Manila in Beijing and also Jakarta in Beijing also. I think the same. Something like that, Doctor. Yeah.
So I think that's a very good point, Pulong. So I'm glad you raised that, because as I said, a rules-based international order is to everyone's interest. So if you look at the Law of the Sea Convention, it's actually so the exclusive economic zone was I'm flagging to you the convention itself. So if you're interested, read the UN Convention on Law of the Sea. So in the EEZ, so Pulong was saying, within the Indonesian EEZ, you have exclusive rights of exploitation, exploration, conservation, management of your living and non-living resources. That's exclusive. So, which means you have the right to repel, expel, and also enforce your laws and your fisheries laws, all of your laws. I mean, including boarding, inspection. I think Indonesia carries this too far when you blow up vessels. But I mean, having said that, remember, I forgot the name of your fisheries minister. I mean, legally, it's always the extreme case, but I think it's also understandable because, as I told you, this is also a case of power posturing. So you have to project your power, because otherwise you will not be taken seriously, right? And anyway, in diplomacy, you always have to have the maximalist position. So even in my case, when the government asks me for advice, I always give what is the maximal or the maximalist or the maximum position, and what does the law or international law say. So for the Indonesian EEZ over Natuna, it's exclusive rights to the living and non-living resources, fisheries, oil, whatever you can find there, which means China has no right to be there. So you can actually expel them and enforce your law. So, as Pulong said, sometimes this also applies to the other fishermen from the Philippines and Malaysia as well. So you of course you can enforce your laws against the Philippine, if they encroach in your EEZ as well, or the Malaysians, and also that this includes impounding the vessels, or in extreme cases, filing cases against the fishermen. But this sometimes this causes some diplomatic issues with the other countries, so they have to be done very, very sensitively. And of course, China. The main issue with China is that you really cannot trust them, because I've been doing a lot of speaking engagements and also dealing a lot with other scholars in the region. There's really a mistrust. It's a trust deficit, because they sit in the negotiating table, they will tell you this, and then they behave differently. In fact, just yesterday, I think they issued a statement against Australia, because Australia is now having a partnership with the UK and the US. So Australia is building nuclear submarines. They don't like that. So everything that they don't like, they oppose, but they do the same thing. So it's really almost I wouldn't say funny. It's actually very worrisome that you cannot trust them. And
indeed,
those are my thoughts.
Yes, actually, before I continue my second point, maybe in conclusion, we can have a 2 point in here. The first point, I think that the claim by China is very unilateral claim, which is that very subjectivity value, I think, and we don't like it in Indonesia actually. And the second, both Philippines and Indonesia, we must have fight our sovereign right in EEZ, because we have a sovereign right to just establish in our EEZ. So before I continue in my second point, maybe you can pay attention in the chat box. They have question for you, Dr. Bautista. Yes, from Laili Arjani.
Laili Arjani, if Indonesia has enough evidence of the seized territory with strong legal standing using UNCLOS, whereas China is using the traditional map as their legal standing, in which the map is not an internationally legal instrument, do you think Indonesia has enough data to bring and win this case at the international court? This is
hypothetical question, actually.
Difficult, but very good question. So, you know what? I think from the very beginning, Indonesia is a unique claimant in the South China Sea, because if you look at the literature, the government pronouncements, it always tells the position that Indonesia is not a claimant state. So I think as far as Indonesia is concerned, there's no legal dispute to speak of. So I've spoken with Pa Hashim and some other people from the Indonesian Foreign Ministry. I think this is your legal position. So when the Indonesian Foreign Ministry issues a diplomatic protest, it always prefaces its statement by saying Indonesia is not a claimant state in the South China Sea. And I think that's very, very good, because you'd be surprised that if you look at the coverage of the dispute, oh my goodness, before, of course, I've been looking at dispute for over 20 years now, since I was a student. There were areas before which were never disputed, and now they're disputed. So for the Philippines, because I'm from the Philippines, I get consulted by the Philippine government. Before, there were areas off the coast of Palawan, which the Philippines also thought that they were rightfully ours. They were within the Philippines. They're so close. Like Scarborough Shoal is actually 80 nautical miles from the Philippine shore and 490 miles from Hainan. So you can imagine, it is so far from the Chinese coast, right? And before, these areas were never disputed. So that's why I think Indonesia's legal strategy, if you can call it a strategy, is very, very wise, because you have to insist there's no legal dispute to speak of. Natuna has never been part of the South China Sea. It is not disputed, because I think it was not. So if you look at the ancient maps, if you look at even the South China Sea Nandash line, Natuna, the Indonesian EEZ over Natuna is not included in their claim. But now, maybe because they're running out of fish, they're running out of oil, they're in need of the resources, they want to project, now they want to claim everything. So I think it's a very good strategy. The other aspect of your question, going to international court or tribunal or arbitration or case, again, this is a question of consent. So it will be, after China lost in the arbitration, it will be very difficult for China to ever participate in a you cannot bring it to court because, as I said, this is always the first thing you need to know if you are going to court. What are the risks? It's a 50-50 risk that you will win or not, right? So if the risk is high, of course, that you will lose, why would you go to a judicial resolution? They will not, because they know that their basis is weak. They will never do that. They will not consent to a judicial proceeding for this reason. So I hope I answered that question. So I think Indonesia will, for the same reason that it's not part of its legal strategy, will not take China to the International Tribunal or ICJ or any court. Plus, I think your country thinks that there's really no legal dispute to speak of. You are not a claimant state in the South China Sea, which is very good. I think that's a very, very wise legal strategy. Actually, I attended an International Law Association Indonesia branch lecture last week in honor of Mokhtar, Professor Mokhtar, and yeah, I think there are a lot of. I was very proud because I read Mokhtar's contribution in the Law of the Sea. It's not the occasion today, but I invite you to look at the archipelagic regime passages. You should be proud to be Indonesians because there are a lot of lawyers from Indonesia who have also made a contribution in the Law of the Sea, especially in the archipelagic provisions.
Okay.
Other questions?
Yeah, thank you, Doctor. Actually, this is very good answer to my question. The question to Riley. And good response. But maybe if I can say that Indonesia is very tactical and play safe. If I can say, yeah, I don't want to have to be party boomer, but yes, sometimes because we are engaged very strong now with China, sometimes we see also the political interest. So if we talk about have the political interest, the language is politic, and depend on the scenario that they want, but have diplomatic approach itself. So that's where that, yeah, it's tactical sometimes and play safe. Yes. And Doctor, I have my second point, and maybe you were to respond or react with my second point. And regarding about your PPT, you mentioned about, it's unlawful also from the Spratly Island or Mischief Reef that maybe carried by the China to just like defend the waters in Southwest China Sea. So what do you think about the Article 101 113 actually? In section 3, that actually this is mentioned about this is mentioned that actually that the the island in China actually can be classified as the natural island actually, so cannot be accepted. But my concern is now they try to be like bringing in the surface of the island, they bring about half the life of the people, a community. But the wars is like the military activity. So it's treat the Filipino national security. So can you respond with that, Doctor? Because actually it's not only the law of the issue itself, but also the national security and the sovereignty itself. So you respond, Doctor?
Again, a very good point. So if you look at the Law of the Sea Convention, Article 121 actually is the regime of islands. So what is an island? So the word island has a very technical meaning under the Law of the Sea Convention. It has to be naturally formed. It has to be above water at high tide. And very important, paragraph 3, it has to be capable of human habitation and economic life of its own. So just with the first requirement, it has to be naturally formed. You should be able to apply that to the artificial islands. They will never become islands. That means artificial islands or islands which are not natural will not become islands. So now you know what an island is. What is the implication? So if a feature is an island, it will have the full suite of the maritime zones. So a territorial sea, EEZ, continental shelf. If you look at Article 121, paragraph 3, if it's not an island, which means it's a rock, it can only have a territorial sea. Okay, so all the artificial islands that China constructed are not islands under the Law of the Sea Convention. They're not entitled to any maritime zone. They're only entitled to a 500 meter safety zone. Okay, so that's their entitlement. So they will never be able to, ripen into islands. They will never be islands. In fact, the tribunal said all the features in the South China Sea, including Ito Aba, which is the largest, 1.4 kilometers it has. Taiwan was not very happy with this because if Ito Aba is not an island, the other features will never be island because they're so tiny. So I told you some of them are even no larger than a table, and some of them are just coralline formation. They're not even rocks. There's no soil to speak of. They're just corals that form over hundreds of years, deposits of sand because of the formation of the coral. So that means they're not islands. But as Pulong was saying, there's an element of security involved because they've not only brought sand from the shores or dredged the sands to form the islands. They've also put military installations there. There are radars there. There are runways there. There are supposedly missiles, even capacity for submarines and so on. So in themselves, these are not innocent structures, right? So they can be used by China to project their naval powers. It can also be used to threaten. I mean, you can imagine if the missiles have the capacity to launch an attack, that's a security issue. They're also a navigational hazard because, as I told you, $3 trillion pass through the South China Sea. If you put artificial islands there, of course, they will impede navigation, right? So there are a couple of issues, plus the marine environmental issue. These are fishery grounds, so they have caused damage to the environment as well. So these are all made clear in the award. China violated its rights, its obligations under the convention, but what can you do, right? So I've been asked by the Philippine government as well, what can you do? So imagine if you have a house, you have a backyard. That backyard is part of your territory or your ownership. Someone built, let's say, a structure in your backyard. What can you do with that illegal structure? I think Rihandi teaches civil law, so you can actually dismantle that. You can do whatever you want to that illegal structure, right? Including asking for reparation or payment. But it's not as simple as that with China, because if you do that, they will think of it as a equivalent to an act of war. And of course, the Philippines and other countries don't have the capacity to really engage in a military fight with China. So that's why it's very complicated. But on the other hand, if you look at it from the perspective of China, it's also acting in bad faith, because if you look at the declaration of the code of conduct of the parties in the South China Sea, they were not supposed to do anything that will change the character of the dispute. Because the problem with these kinds of actions, they change the character of the dispute. It will be difficult now to unravel that, because how can you ask China to withdraw from these features and so on? They were acting in bad faith. They should not have done that, because it would be difficult to enforce anything against China because of the disparity. So going back to Pulong's question, they're not islands. They're not entitled to any of the maritime zones. They're only entitled to a safety zone of 500 square meters. Looking at the other features, there are about 60 occupied features. They're all classified as rocks, which means they're only entitled to a territorial sea. But then the ownership is still in dispute. So that's where we're at now.
Thank you very much. So my final question will be regarding your conclusion. You mentioned and attached about the hegemony position. It attracts also the proxy war. So actually they have also the claim by the China. It's very obnoxious claim to the Philippines, because the proxy war that actually if China make a statement that Philippines backed by US. So what do you want to respond with this claim by the China, Dr. Bautista?
So I think, so obviously there's so if you look at history, there of course, many times in history, And Indonesia will know this as well because you were a colony of the Dutch for a long time.
Correct.
Spain was our colonizer for 300 years. There will always be a global superpower. So at one point, it was Spain, it was Portugal, it was the UK. So we should learn from history that at some point, it's possible that the global superpower, which is at the moment the United States, will be replaced by another superpower. And at the moment, it's actually in decline. You can see that just recently it pulled out of Afghanistan. It's becoming more and more hindered by its domestic, policies. It's very difficult to be a global superpower. You have to throw away money. As I said, the regional security architecture is underwritten by the United States. It's not cheap. They have to make bases. They have to make huge donations. You have to project your power. The phone ops that they do, the freedom of navigation, it's very costly. This will cost millions of dollars just to make the vessels run through the South China Sea. I don't know how long it can keep on doing that. Some scholars say it will, because they can already track the decline. America is in decline economically as a power. Militarily, it's still far, far ahead compared to China. But economically, really, they say 20 years, 23 years, less than 50 years, definitely China will overtake the United States. So what kind of world do we imagine? So let's say in 20 years' time, China becomes the global superpower. That's fine. I have no problem with that. But the problem with that is how it's behaving, because as I said, we want a rules-based order because I'm speaking as a lawyer, we should respect international law. We should respect the spirit and letter of international law. Otherwise, it would be very chaotic, right? So if you have a hegemon, a global superpower, which is misbehaving, you should be very afraid because that means if it's flouting international law, not honoring international law, not honoring awards, doing as it pleases without respect for order, then it would be a very scary world. That's why I'm flagging that. But of course, we can be assured there's a power of global opinion. There's a community of nations that should be there to put a check on China's behavior. So hopefully there will be enough public opinion within the region and beyond to make sure that China is not breaking international law, because otherwise it's bad for everyone. It's not just the Philippines versus China or Indonesia versus China, but it's really a bad scenario for everyone. So as I said, it's really a question of the kind of future you want to have for yourself. So if you want an orderly, peaceful, global order, then we should hold China into account and make sure that it respects international law and the provisions of the law of the Sea Convention, because it's the maritime area.
Okay.
Are there any more questions? Where are the questions from the students? Are you guys sleeping? This is why I don't like if you're in.
Actually, because in my opinion, if I can say that you are one of the best notable speaker that we have so far, because you're very informative, very attractive also, and very passionate to answer the answer or either way to respond to the question. That's why that our student maybe know it very well that you speak it very comprehensively. So Doctor, I think, because there's no question, I think I'm very enjoyed. We did very enjoy it with this conversation. And I believe that they must have fruitful conversation that we opened our discussion today. So on behalf of the Faculty of Law and also International Office in Faculty of Law Universitas Diponegoro, I say thank you very much and very high appreciation that you have for this opportunity that you have very want to have just personally in our visiting lecturer and visiting professor itself. So it's very, very nice. And I believe I keep your promise that this is not the final visiting lecture, but maybe in the next occasion or the next year, we will like to waiting you in person also in our Semarang and our campus in Universitas Diponegoro itself. So in this special occasion, I would say also to thank you from the IMHI for the information, Doctor. IMHI is like student association that who concerned with international law that very pretty well to organize and help us to this visiting lecture. So Bianda as the host is also the IMHI as well. So thank you very much also from the IMHI to take a part in this prestigious program. So I think that's all, Doctor. I think we have very enjoyed it. Now I'm back to I offer to the Bianda. Thank you very much.
Well, can I say a few words?
Yes, you have a closing statement, please. Yes.
So thank you so much thank you so much, Makasi Banyak, for those kind words. And you know this for a fact. When you emailed me, I didn't hesitate. I think I consider it personally an honor to be here. I know, as I said, Universitas Diponegoro is a very good university. I've also asked around. So I just want to encourage your students to explore this opportunity because as you know, I'm also originally from the Philippines. And I know for a fact that I have a lot of Indonesian friends, and I know I have very strong relationship with other universities in Indonesia. So again, I wish you all a safe, that you're safe, you look after yourself. It's very difficult times, and also explore opportunities because I commend Pulong and your Vice Dean and Rehandi for all of your efforts. Hopefully you're inspired to study, postgraduate degrees overseas. You can apply for a PhD or a master's, not just in Wollongong, but any other university. It will really enrich you, and also to appreciate, the efforts of your teachers that they do this. Because let me tell you, not every university does this. And I hope that it's not a long time. It's just 1 hour and a half, but hopefully you're able to learn. My publications are available for you to download and read. And I hope that we can also collaborate in research and also exchange and other stuff. And again, I wish all the best, and I appreciate the time. Stay safe, and hopefully I can see you in person. And likewise, if you come over to Wollongong to visit, or Sydney, just let me know. And you're always welcome.
Thank you very much, Doctor. So I think that we hope also that they have academic collaboration, maybe in the double degree or exchange program. And maybe we have also summer course. So you must promise, and I will asking you promise to just to be have speaker in our summer course. And I think that it will be have interesting, Doctor. So see you in our summer course also. So turn on back to the Bianda, please. Thank you.
Thank you so much, Mr. Pulung Widihananto, for guiding us towards the discussion session. And I would like to say thank you as well to Dr. Lowell Bautista for lecturing us today with such insight and knowledge. I hope you a very good health during this pandemic. Ladies and gentlemen, we come to an end of the session. Before that, we are going to have a photo session that will be led by me. By that means, to all participants, please kindly turn your camera on and please be ready. I repeat once again, please kindly turn your camera on and be ready. Thank you. We will begin from the first slide on my count. 1, 2, 3. Next slide. 1, 2, 3. Okay, to the last slide. 1, 2, 3. Okay, thank you very much for all the participants. Ladies and gentlemen, it has been a very wonderful afternoon with all of you. I hope today's visiting lecture brings enormous insight and influence for all of us. Thank you for your time, and see you on another occasion today. Thank you very much.
Thank you, Dr. Bautista. See
Thank you,
you.
Dr. Lowell.
Thank you, Dr. Bautista.
Thank you, Dr.
Terima kasih banyak. Thank you. Go. Take care.
Thank you.
can I leave now? Thank you very much. Mas Andi, bye-bye.
Okay,
See
bye-bye,
you in
Mas.
campus.
Thank you,
Yeah,
Mas.
yeah. Thank you, Bianda. Thank you, Imhi. Bye-bye.
Thank you.